Welcome to our continuing 2021 educational webinar series. I'm Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business. A hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility, and we help manage every aspect of a compliance program, and our training library provides hundreds of modules that are easy to assign and track. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Catherine Walters, a management side labor and employment attorney representing employers of all sizes, including privately and publicly held companies, federal and state government contractors, institutions of higher education, trade associations, and other nonprofits. Industries served include financial and banking, manufacturing, defense contracting, education, healthcare, professional services, insurance, construction, technology, retail, real estate, transportation, restaurant, and hospitality. Catherine partners with clients to develop creative, practical, business-oriented solutions, and she focuses on identifying current and emerging trends to assist clients with managing and preventing emerging risks. Emphasizing strategic thinking and focused solutions, Catherine provides employers with a sophisticated counsel that has become necessary in today's complex business environment. She appears before federal and state courts and administrative agencies, and currently is a partner at BYBEL Rutledge LLP. Before we begin, I would like to mention at First Healthcare Compliance, we strive to serve as a trusted resource for compliance professionals, and every month we celebrate their hard work and dedication with our Compliance Super Ninja recognition. For this Super Ninja, our team has been turning the spotlight on Betty M. Perryman, administrator at Southern Avenue Family Practice. Betty says, I have worked with my doctor for many years, and I really enjoy the interaction with patients. We have a concierge practice, and we are able to spend more time with the patients when they come in. Our staff has been together for a long time, and we work well as a team, and it is a pleasure working with them. Congratulations, Betty. Our team is honored to have the privilege of working with you. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your PACOM and PMI CEU certificates will be emailed to you following the broadcast. Your PACOM certificate will come directly from PACOM, and your PMI certificate will come from our email. There is no need to request either one. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. So Catherine, it's a pleasure to welcome you here again with First Healthcare Compliance. Thank you so much for being here.
Thank you so much, Catherine. That was a lovely introduction. And congratulations to Betty. I think being a ninja, I aspire to something like that. I wanted to add one little thing to my introduction that Catherine provided, just to point out that I may be with a very small firm at this time. It's a small boutique firm that allows us to provide a sophisticated legal service with a personal touch. I spent over 25 years in international and national firms, and about 2 years ago decided to make the move to small law, where I could really focus on my clients and providing, again, great legal services, but with a personal touch in my little boutique style. So it's a pleasure to be here with First Healthcare Compliance. I've worked with them over the years, and I think that they're also excellent. So let's move on with the program here. Today's agenda really is going to be all about the current status of things under President Biden's brand new administration. I'll touch briefly on the presidential election and its outcomes, and focus then on President Biden's anticipated impact on U.S. labor and employment policy. Now my mantra, though, and you're going to see me use this mantra, you're going to see slides about it, but this is my motto for the next couple of years. It's buckle up, America. So we had Biden versus Trump. And interestingly, the over 159 million Americans voted in 2020, and this was the largest voter turnout in American history. It is also the first time that more than 140 million people voted. Interestingly, the Electoral College was the same as it was when it was Trump versus Clinton. It was 306 to 232, the same margin that Mr. Trump beat Hillary Clinton by in 2016. And at that time, he referred to it as a massive landslide victory. In this particular case, each of these gentlemen got more votes than any other presidential candidate in US history. It's just that Joe Biden received more than Mr. Trump did. Now, I will point out that the midterms are going to be held in November of 2022. All 435 House seats are up for grabs and 34 Senate seats are up for grabs. So my perspective is that Mr. Biden needs to act now while he has a Democratic House and a tiebreaker Senate. He may never have as good an opportunity to get things done as he does now. And I'm saying that not because I want to see a lot of different laws and I want to see a lot of changes to the laws, but quite frankly, I think a very good management attorney also considers the safety, health, and well-being of employees. And I do think that a lot of things that happened during the Trump administration were not good for employees, even though they were excellent for employers. So I'll be touching on that kind of dichotomy as we walk through this. As I indicated, I'm thinking that Joe should carpe diem, seize the day. Others think he needs to be more conciliatory like Mr. Obama was, to try to build consensus given our political climate. But again, that hasn't worked well in the past. And as a result, if Mr. Biden thinks that he wants to achieve some things, it seems to me that he better move now while he can, because who knows what's going to happen in the midterms, and he may never have this much political capital available to him again. So moving back in time a little bit, if we look at the Trump labor agenda for the last couple of years, the focus really was on deregulation. Deregulation meant rolling back multiple executive orders issued by President Obama, reforming multiple immigration laws and practices and policies, weakening labor unions, and creating jobs. As I said, deregulation was the key word. And I thought this was just a funny picture because this is kind of the way Mr. Trump approached a lot of things. Some of it worked really well and some of it didn't. With respect to the jobs creation, it was happening kind of at a slowish pace during the Trump administration. But unfortunately, with the pandemic, any jobs gains that he had made during his term were eradicated, and net, more jobs were lost than created during his term. And also during the Trump labor agenda term, we saw tremendous budget cuts and agency downsizing and rollback of multiple Obama-era executive orders and a lot of employee protections. The DOL, of course, had fewer resources for investigation. And as in most Republican administrations, it was more focused on conciliation, more outreach, education, and clarification, more conciliation, really, and more flexible in interpreting the law to favor employers. Really, there was a tremendous suppression of DOL enforcement activity. On the other side of the coin, it was a very decent 4 years for employers who might otherwise have been slammed by DOL audits and other enforcement activities. Plus the NLRB and Wage and Hour issued numerous employer-friendly guidances, letters, and other rules and regulations, sidestepping or otherwise cramming down many of the initiatives that had begun under the Obama administration. Interestingly, the Department of Labor, a lot of it shrunk due to attrition. Lots of folks retired with nice buyouts. There was a lot of attrition without replacement. And so the fewer employees, then the fewer audits and investigations, less enforcement, more conciliation, and what I considered to have been a fairly low-profile DOL. The highest profile aspects of the DOL really were the NLRB, where they were focused on eliminating a lot of the union and collective bargaining friendly procedures and practices. I think that the NLRB had a high profile during the Trump administration, but it wasn't really functioning in the fashion that it was intended. Interestingly, too, in 2019, Mr. Trump was able to tap a prominent management defense attorney for DOL secretary. This was after multiple failed attempts to retain a labor secretary. So Eugene Scalia, of course, the son of the late Supreme Court Justice, came in, and the Department of Labor became jokingly referred to as the Department of Management. As I said, Eugene Scalia is a well-regarded management defense attorney. He came from Gibson, Dunn and Crutcher at that time. However, according to a former senior OSHA official, Mr. Scalia believed that the Occupational Safety and Health Administration should have no role in managing the COVID-19 pandemic, and that this belief has been credited with exacerbating the failure to control the disease, particularly in the workplace. Interestingly, in October of 2020, just before the election, the New Yorker characterized Mr. Scalia's tenure as Secretary of Labor as one of antagonism towards labor and weakening of workers' rights, and referred to him as a wrecking ball aimed at workers. The Labor Department changed rules that made it easier for firms to not pay workers for overtime, allegedly made it easier for restaurants to shortchange waiters on tips. Again, we're talking about the tip pooling issues, and made it easier for companies to not provide paid sick leave. The definition of independent contractor was changed to make it easier for firms that use contract labor to avoid paying the minimum wage, overtime pay, and other benefits. And as we'll discuss, the Biden administration has already taken aim at most of these policies, and they will be revisiting OSHA and COVID-19, overtime and the minimum wage enforcement, tip credit and tip pooling, independent contractor status, and joint employer status. Interestingly, too, we have seen the typical Democratic, Republican pendulum swing. And under Mr. Trump, the pendulum had been swung very far to the right. And under Mr. Biden, it's not going to swing in the middle. It's going to swing very far to the left. Now, Mr. Biden is not the progressive liberal, but he is a very liberal Democrat when it comes to labor and labor policy. Not as liberal as Bernie Sanders, who is going to have a role in a lot of what Mr. Biden achieves. But I do think that we're going to see, the flip and the flop, the back and the forth, the yes and the no, and so forth. We're going to see a lot of changes, and we already have. It's really about priorities. And so in January, immediately, Mr. Biden moved to institute a broad regulatory freeze on a number of the last-minute rules issued by the Trump administration, and directed agencies across the federal government to withdraw or delay action on potentially dozens of regulations. In essence, there's something called midnight rulemaking, and a lot of agencies are pushed into issuing rules, trying to get policies through just before an election, in the hope that they aren't frozen or otherwise a stop put to them under various different procedures that are available, whether it's the CRA or some of the later types of things related to the midnight rulemaking. So Mr. Biden has basically directed agencies to immediately withdraw any newly finalized rules that hadn't yet been published in the Federal Register, and then to consider 60-day postponements for rules that had already been published but that had not yet taken effect. And this really opened the door for the Biden administration to seek to block some of the changes that were about to take effect, such as the independent contractor rule. Again, it's basically referred to as worker classification regulations, So we're focused on this independent contractor rule, worker classification regulations, and how that will impact gig workers in particular, but not just gig workers and others who might be considered independent consultants, but who rely almost exclusively on one employer for their income. Other things that we're going to see besides the delay on the independent contractors is on tips. There's a number of things having to do with tipped workers. One thing has to do with tip pooling and whether it's okay for front of house employees to be required to pool their tips so that back of house employees get a portion of that. That serves to reduce the wages that front of house employees actually earn. And many of them, not all of them, a lot of hospitality employers do not use the tipped wage rates, which are substantially lower than the regular hourly wage rates. They just pay hourly wages and then they use the tip pools. But a lot of employers are still using the lower tipped worker wage rates, which can be anywhere between, you know, two and change and four and change. And then they must live on the balance is made up by tips. And by sharing all of these tips with the back of house workers, the front of house workers were making less. And under a new rule that the Trump administration pushed out in the waning days of the administration, there was also the ability of tipped workers to work at different jobs at their tipped wage rates. So they were actually going to have to roll napkins and do other things that didn't include waiting tables for tips at the tipped wage rate. So those things have been held up now. They are blocked, and we're going to see some changes coming there. I doubt that we're going to see reinstatement of the independent contractor rule or the tip workers rules that have been blocked for now. Some other things that we're looking at, of course, is where are we going with Mr. Biden? Back to the future, I'll say to some degree. I will say that Mr. Biden was 100% behind and supportive of much of President Obama's labor policy. And so we're going to see a lot of the Obama labor policy creep back into the Biden administration. But I will say this, Mr. Biden is his own man. And he was actually a bit more aggressive in practice and the concepts that he espoused as vice president. So I expect that as his own man, he will actually be more aggressive in seeking worker protections and overhaul of various laws and regulations that really in this day and age require overhaul, particularly in the wage and hour arena. Mr. Obama was indeed aggressive, but much of his good work had to be done via executive orders and reinterpretation of current laws. As I indicated earlier, he unfortunately, in my opinion, did not take full advantage of a supportive Congress in his first 2 years because he felt that being more conciliatory would be better for the country. And as a result, he encountered probably the most obstructionist Congress in US history, maybe until recently. So we will see Mr. Biden seek to put new laws in place, and he's going to use executive orders to achieve some goals where perhaps he doesn't have the time or can't get certain legislation through. But again, it gets back to their concept. If we can't pass new laws, we will reinterpret and enforce the ones that we have. So as we go on through with this Back to the Future theme, I'm just highlighting some of what Mr. Obama's administration did. It had an extensive impact on labor and employment policy, again, even without support from an obstructionist Congress. And I'm not going to read this slide to you, but you can see it was just more of everything that was intended to protect employees. The interagency cooperation was a big deal because what we were seeing was communications among wage and hour, among the OFCCP. So it would be wage and hour and OFCCP if they were dealing with a government contractor, or OFCCP and the EEOC and so forth. Um, and I think that we're just going to continue to see more and more of that. Enforcement litigation is going to increase again. We will have seen more audits, more discrimination filings, more compliance, regulatory things happening. And again, this is because Mr. Biden has pledged to increase the number of field investigators, and he's going to enhance enforcement at the various agencies with a focus on technical violations. At the OFCCP, we're going to see enhanced enforcement with a focus on recruiting, back wages, and technical violations. Pay equity is going to be big across all of the different agencies, particularly at EEOC, OFCCP, and Wage and Hour. And in essence, employers need to really get prepared with some of their wage and hour practices. It's always a good time to do a self-audit, but as time is passing within the new administration, the time is even better to self-audit yourself. Some of the other things under the Biden labor agenda will be to reverse a number of multiple Trump era executive orders. He's already done that. I think we'll see reinstatement of Obama era orders, whether they're reinstated in full as written or with a different spin or more of a polish to them, but we're going to see some of the same concepts come out. We are going to see an amazing focus on pay equity. There's a goal to increase the federal minimum hourly wage from the current $7.25 to $15 an hour. Most of you probably are aware that that part of the pandemic relief bill, or the Save America Act, was eliminated by the parliamentarian as not, it wasn't permitted to be included in that bill. So they're going to have to go at the $15 an hour another way. And I hate to say this, but I appreciate that. I don't think that the pandemic bill was the place to put a $15 an hour increase, because there needs to be studies done. There needs to be a lot of airing of this issue on both sides of the coin. And it's more than doubling for the current minimum wage. I agree that the minimum wage must be increased substantially, but I don't think putting it into the pandemic relief bill was the place to do it. It's a good start, but they're going to have to do it straight. We're going to see a reinvigoration of the NLRB's focus on employees as opposed to employers. And then, of course, strengthening of unions, the ability to unionize, encouragement of family-friendly legislation, the restoration of the broad definition of joint employer, increased protections for gig economy workers who are currently being misclassified as independent contractors in many cases, although in many cases it is appropriate to classify them as independent contractors. Remember, in labor and employment law, and particularly with respect to independent contractor classification, it's a fact-specific analysis, and it's difficult to provide really a broad or generalized approach to some of these things. There's a move on to limit non-compete and no-poach agreements. Whether that happens, I don't know. I can't predict that it's going to happen. I know that it's on Mr. Biden's agenda, and it's something that he doesn't like and would like to get rid of. And I think we have to be on the watch for that. I don't think it's in the top 5 of the immediacies, but I think we should be watching out for that. And then I know Mr. Obama would like to, Mr. Biden would like to restrict employer use of mandatory arbitration agreements and class action waivers. Other aspects of the Biden labor agenda include the nomination of Boston Mayor Marty Walsh for DOL Secretary. And in studying all of the potential nominees, I had actually chosen Julie Su to be the new DOL Secretary, and Marty to be in the DOL, mostly working with the National Labor Relations Board. But I'm happy to say that Julie came in second, because she has been nominated for the Deputy DOL Secretary. And Marty Walsh, being in first, is likely going to sail through the confirmation hearings he's already gotten through committee. He's a very interesting man. He is union guy through and through, blue collar through and through, very focused on collective bargaining. He's been involved with unions since childhood because his father was in the laborers union. So he's a Boston fellow. He is the son of Irish immigrants, I believe. He started working at the laborers union local at the age of 21. He served as the president of the union, was elected to serve as a Massachusetts state representative for 16 years. And around the age of 42, he went back to Boston College at night to get his bachelor's. He was also elected to head the Building and Construction Trades Council. And then he was elected to the mayor of Boston in 2014 and has been in that position ever since. What folks who work with him say is that he's flexible when it comes to working with management, and he is a progressive liberal on social issues. He's pragmatic with respect to problem solving, and he does strive for unity and consensus building, but don't be misled by that. He is a very strong proponent of employee rights, and he and Joe Biden walk hand in hand as blue collar guys. So I think that we're going to see a very different attitude in the Department of Labor. Even under Obama, the Department of Labor was extremely activist. He had some very good people, as under the Clinton administration. But I think we're going to see a very strong focus now on union issues and collective bargaining. Interestingly, less than 11% of the U.S. workforce are unionized. However, Mr. Biden has indicated that one of his primary goals is to increase union membership, to make it easier for employees to organize, and to enhance the collective bargaining process. So I think that Mr. Walsh is probably best suited for this type of an agenda under Mr. Biden. With respect to Julie Su, she is the daughter of Chinese immigrants, and she speaks both Mandarin and Spanish, in addition to English, of course. Before entering government, she worked in the nonprofit sector with vulnerable communities. So she was seeking workplace justice for vulnerable communities. And a fascinating little tidbit of information, she received a MacArthur Fellowship, which is also known as a Genius Grant. And this receipt was for her advocacy on behalf of immigrant laborers. She comes to us from the California Labor and Workforce Development Agency. And at that agency, she managed agencies charged with wage enforcement, occupational safety and health, unemployment insurance, workers' compensation, and job training. She also oversees agencies that regulate labor management relations in agriculture and state and local employee workforces. And most of that has been largely excluded from federal oversight. So I think, again, we're going to see a Department of Labor that is going to focus more on what I consider to be kind of the nuts and bolts areas, labor law, OSHA, occupational and apprenticeship issues, wage enforcement, whereas in the past we've seen more focus on discrimination and things that weren't quite as, I think, workplace safety and workplace oriented. I think discrimination, of course, is very meaningful, and I'm going to be getting into that in a few moments, but we're going to see a larger focus on OSHA, on the National Labor Relations Act, and wage and hour issues, particularly pay equity. So will policy reforms be successful? I think so in many regards. Will they have more luck getting new legislation through the Senate if they act quickly? While there's still it's a 50-50 Senate, but Vice President Harris is the tiebreaker, so they have a better shot at getting new legislation through at this time. However, there are some issues with respect to the filibuster and whether a bill is going to pass by 51% or 60 votes, 51 votes versus 60 votes. So there are issues there. But even short of full support from Congress, I think the Biden administration can certainly achieve many goals. And as I said, If they can't pass new laws, they'll simply reinterpret the ones that they have. So as I said, folks, buckle up. We're going to see a lot of change going forward. Now, President Biden has definitely been busy. Since his inauguration on January 20th, he's issued dozens of executive orders and frozen numerous Trump regulations and other actions, especially that midnight rulemaking that we talked about earlier. So I'm going to take the rest of the time here to discuss the items on this slide. I'm going to just hit each agency as quickly as I can and propose legislation as it goes. So some executive orders that affect federal contractors in the workplace. Remember that an executive order that directs an employer to actually do something like pay a higher wage or to require employees to mask, that can only apply to federally regulated employers like federal contractors or a federal government workforce. So what we see typically with executive orders is setting the table for what will happen in the private sector after the federal sector has been regulated. Other types of executive orders will typically require an agency to do something. So what we've got currently moving out there is COVID-19, several things where Mr. Biden has sought to fix the COVID situation. So there are several orders relating to COVID and basically taking care of the pandemic. But with respect to the workplace, he has basically ordered the Occupational Safety and Health Administration to issue revised guidance to employers on workplace safety. And they did follow this already on February, prior before February 4th, they issued some new guidance, and then they're required to issue emergency temporary standards by March 15th. And I suspect that that will happen based on the speed with which OSHA moved to issue the revised guidance. Now, the order didn't provide any details about the measures that OSHA must consider, but says that the guidance must be science-based, including with respect to mask wearing. So in essence, we look to some of his other executive orders, and one of them has to do with protecting the federal workforce and requiring mask wearing of anybody who is on a federal property, any federal employees, and again, federal contractors. And so a lot of this includes testing, tracing, physical distancing, occupancy and density standards, personal protective equipment, air filtration, enhanced environmental disinfection and cleaning, telework options, and vaccine administration. So I think that that executive order highlights what we're going to see when OSHA issues its emergency standard. So be on the lookout for the emergency standard. I will hit what OSHA has done thus far later in this program. Some of the other executive orders, one of them is called Economic Relief for American Families and Businesses. That is the American Rescue Plan. In essence, he is looking for the $15 minimum wage, which is in line with the new Democratic Raise the Wage Act of 2021, which was introduced in January. So what Mr. Biden is trying to do is raise the minimum wage, at least for federal contractors and other workers, to $15 an hour. Currently, federal contractors, as of January 1st, have an increased wage rate. It's either $10.90 per hour or $10.95. I honestly don't recall at the moment. It just went up. Another one is ensuring that the future is made in all of America by all of America's workers. This executive order focuses on in control over the Buy American Act waivers, which are currently managed by individual government agencies. And so Mr. Biden has created a Made in America office within the Office of Management and Budget, the OMB. And this new office, will have centralized control over Buy American Act waivers. And I think we're going to see a lot of stringent denials of requests to use other products made in other countries for some of our federal contracts. It's going to be interesting, and that is intended to create more jobs, of course, in the United States, and also to reshore jobs from other countries for United States owners. Another area where we've seen executive order activity is in racial equity. At least 4 of Mr. Biden's executive orders are focused on advancing racial equity and the support for underserved communities. And one of the executive orders that Mr. Trump had issued back in, I think it was September, was Executive Order 13950, which had prohibited the concept of, quote, divisive concepts, closed quote, in diversity and inclusion training by the federal government, federal contractors, and federal grantees, even if they aren't federal contractors. And in essence, this was just a mean-spirited order that provided the opportunity for employees who were unhappy with the diversity and inclusion training that they were receiving to call a hotline and report that a hostile environment was being created in their workplace. The OFCCP was in charge of that hotline and has shut it down. So that's dead and over. It was just another one of those really mean-spirited things that had a tremendous impact on the ability of employers in the federal contractor area to actually execute on required diversity and inclusion training. Some of the other things that we've seen is the prevention and combating of discrimination on the basis of gender identity or sexual orientation. Now, this is an executive order that ensures that the U.S. Supreme Court's decision in Bostock, where the court ruled that the prohibition on sex discrimination in employment includes a prohibition of discrimination on the basis of sexual orientation and gender identity, is to be applied immediately by all federal agencies and so forth. And so again, it doesn't change anything for employers outside of the federal sector, but it highlights what we're going to see happen with respect to new legislation and agencies. And I'll talk to you about the Equality Act, which has just come through the House, and that is really intended to push or actually instate the Bostock decision. And I'll talk about the Bostock decision in just a second. I don't want to spend too much time on Obama-era executive orders that had been rolled back by Mr. Trump. Just to say this, on this slide, the ones in green are the ones that are still alive. The one in gray is the one that has been weakened by the retraction of the one in black, the Fair Pay and Safe Workplaces Act. Now, I was all for retracting the Fair Pay and Safe Workplaces Act. It's called the blacklisting law in normal parlance, and it provided for extensive reporting of labor law violations when bidding on a government contract for goods and services of over $500,000. It had very stringent standards, and just even one nuisance claim of discrimination might have prevented a large contractor from getting a bid. It was to have been effective in October of 2016, but it was enjoined, except for something called the paycheck transparency provisions. And so there is some difficulty, I guess. I'm not coming up with the right word to describe this, but by pulling back the Fair Pay and Safe Workplaces Act executive order, it did limit to some degree some of the other executive orders that had been passed in the Obama era. I think this is all by way of saying that I expect Mr. Biden to come back to the Fair Pay and Safe Workplaces issue. Now, whether we see the same language or some, I would hope, I don't want to call it dumbed down, but some less stringent language in what I expect him to do in the near future, it would be good. But I think we're going to see another version of the quote unquote blacklisting executive order. But I do hope to see, if it does come out, I do hope it will be slimmed down and less stringent and make it a little bit less difficult for employers that battle internal issues on a regular basis. It'll make it a little less difficult for them to continue to get contracts and provide work for their employees. All right, moving forward, let's talk a little bit about the Biden Office of Federal Contract Compliance Programs, the OFCCP. Interesting choice for the new head of OFCCP, Jenny Yang, a former commissioner and chair of the EEOC during the Obama administration. She is amazing. She is a lawyer. She is really focused on pay equity. She was a strong proponent of what many of us refer to as the horrific EEO1 component 2 pay data collection rules that were back and forth in the courts and were finally basically just beat up so badly that it changed the face of the EEO1 compensation data collection requests and requirements. The impact of all of that back and forthing and courts and injunctions and so forth was to actually change the filing of your EEO1 forms from September 30th to March. So we'll see what happens with the EEO1 form. I'm straying a little bit over to EEOC territory by talking about this, but she was a large proponent of that issue. And so what she brings there is the focus on hiring and pay equity enforcement. So the OFCCP is going to go back in the direction of pay equity, as well as systemic discrimination relevant to hiring and systemic discrimination relevant to pay equity. I pity federal contractors that end up with some of these pay equity audits, but they should really be focusing on looking at what the OFCCP is planning to do on pay equity and start again self-auditing, checking to see if there's anything negative going on in their pay issues, and looking to see if there are differences between males and females or whites and minorities. Let's find out what those issues are and whether they are defensible. So I think what we're going to see is a strong return by the OFCCP to aggressive enforcement activities. It's very interesting because when Mr. Trump took office, the OFCCP was on the verge of being absorbed into the EEOC. It was small, it was underfunded, it lost a lot of people. And under Biden, we're going to see it probably redouble in size. And he's already working with the OFCCP to put together a lot of domestic employment policy. So watch for the reinvigoration or the resurrection of the OFCCP under Jenny Yang. The Biden EEOC, he's already been able to name Charlotte Burrows and Jocelyn Samuels. Both of them were Democratic EEOC commissioners. And the EEOC is still majority Republican, but once the appropriate terms are up, you know that it's going to go full Democratic. So the EEOC may lag a little bit behind the OFCCP in terms of issuing policy, massive policy revisions and enforcement. But I do think that it's headed in that direction as quickly as it can get there. The primary priorities for the EEOC in the coming years are LGBT rights, again, narrowing the wage gap, and that's more of a minority and female issue. So it will work hand in hand with the OFCCP on those issues. And then COVID-19 guidance. Interestingly enough, the EEOC has not yet taken a strong position on whether having COVID or lingering effects of COVID constitutes a disability under the ADA, the Americans with Disabilities Act. I want to go back for just a second to the LGBT rights priority and remind you about Bostock versus Clayton County. You'll recall that last year, the U.S. Supreme Court held that under Title VII of the Civil Rights Act of 1964, sex discrimination was found to encompass sexual orientation and gender identity. Gay and transgendered people are also protected from workplace bias based on sex. This case was the resolution of a trio of LGBT bias cases, and it also was the resolution of a circuit split And that was interesting. The 11th Circuit said sexual orientation was not covered by Title VII. The Second Circuit said sexual orientation is covered by Title VII. And the Sixth Circuit said that gender identity is covered by Title VII. And then on top of it, there was an agency position split between the EEOC and the Department of Justice. Up until Mr. Trump took office, the Department of Justice sided with the EEOC with respect to whether sex discrimination included sexual orientation and gender identity. After the Trump administration began, the DOJ split from that position and wouldn't assist the EEOC with enforcement, which is why the U.S. Supreme Court took the case. And one of the reasons the U.S. Supreme Court took the case and why resolving the circuit split, the actual meaning of Title VII's law, and resolving the agency split was so important. And just so you think about it correctly, the Bostock case simply interpreted current Title VII law. So in essence, the interpretation that sex discrimination included sexual orientation and gender identity simply means exactly what it is. That's what it says, and that's how it should be interpreted. So I would anticipate a slew of cases that will be filed from prior to Bostock being decided, but basing the jurisdiction of the courts on Bostock. All right, so I digress. What about equal pay under the EEOC and the Department of Labor? Excuse me, the Department of Labor Wage and Hour Division. Again, we've got a gender pay gap. We're going to see more focus on the concept of equal pay, but I think the pay equity issue gets to equal pay. So look at pay equity. Pay equity is really about the criteria that employers use to set wages, and it must be sex and race neutral. And that's where we end up with a lot of the pay equity systemic discrimination cases, meaning that an employer's criteria, while it appears to be race and sex neutral, actually creates a discriminatory impact on those individuals. So we're going to see a lot of that. And that reminds you as an employer, look at the criteria that you use to set wages, make sure that it is defensible. If you've got seniority reasons, if you've got educational levels, look at some of the things that might actually have an impact on whether you're a female or whether you are not white. Some of the educational requirements might be suspect under this concept. Certainly other things are suspect, such as whether somebody can do, a math test, or whether somebody's got a criminal background. So we've got to really watch out what the criteria are, not only for pay equity itself in terms of setting wages, but for hiring of people. Remember, under the federal law, the Equal Pay Act is enforced under the Wage and Hour Division that exclusively applies to sex. It's males and females in the same job. Under the Lilly Ledbetter Act, it basically allows an employee who's had a continuing violation, it could be over 20 years old, but if that violation is continued through the decades, to result in a lower wage for her or a lower pension payment, that's a continuing violation. And so it basically is an extension of the statute of limitations. And then, of course, we look at Executive Order 11246 for federal contractors. And then, of course, there are myriad state laws that deal with equal pay as well. So watch all of that. It's very important. When we get to the Biden Wage and Hour Division, again, we've already talked about the priorities of increasing the federal minimum wage from $7.25 to $15 per hour. Mr. Biden has already moved forward with his assisting workers impacted by COVID-19, not only by getting this new COVID relief package, at least into the Senate, where it's now being filibustered, but getting that moving and almost passed. I expect it'll pass in some form in the near. He's also focused on OSHA and the COVID-19 emergency standard, and then some of the other things that we're going to see at Wage and Hour, of course, is what we've mentioned already, the worker misclassification and gig economy issues, renovating the joint employer rule and bringing it back to where, in essence, employees that worked for more than one employer had recourse against both of them under the Fair Labor Standards Act. We're going to see more of an impact on remote work because, of course, remote work is the new normal, and the issues that flow from remote work relate not only to wage and hour issues, but in some cases OSHA, and of course, harassment follows everybody, everywhere, all the time. So we're going to continue to see a lot of focus on remote work at wage and hour, and I think it's going to expand beyond just wage and hour issues. And of course, increased enforcement relative to minimum wage and overtime violations. This list of low-wage industries will likely continue to be targeted, but I expect it to be expanded into less low-wage industries because I just believe that this is what we're going to be getting from wage and hour in the coming years. All right, some potential future changes. I know that there are some rumors that Mr. Biden isn't thrilled with the current salary level that just went into effect January of 2020, where employees moved from a $23,660 per year annual salary to around $35,000. It was lower than what the Obama administration had wanted, and they ultimately ended up, somewhere in the middle. But there's a rumor that Mr. Biden is going to reopen that salary level analysis, and it's my perspective that that's going to be a really difficult row to hoe since it just happened within the last year and a half here. But another way around or at it is going to be the duties tests for exemption. And that's where I would go. If I couldn't raise the exemption or the salary exemption level sufficiently, then I would come at it by taking a look at the duties tests for exemption, because the duties tests could easily be refined to make it more difficult for folks to be considered exempt under the law. And then, of course, they would become non-exempt and subject to overtime and minimum wage. So lots of things I think are coming in the wage and hour area. But let's take a quick look too at the National Labor Relations Board. Oh boy, that was a fun one. Big personnel shakeups. The very first day in office, Mr. Biden fired the general counsel. And the second day, he fired the deputy general counsel because neither of them would step down voluntarily. So Peter Robb and his deputy general counsel, Alice Stock, were both fired during Biden's first 2 days in office. President Biden has named Jennifer Abruzzo, who is a former NLRB acting general counsel, to serve as the general counsel for NLRB, and she's going to have to get confirmed. And then the current NLRB acting general counsel, Peter Orr, has moved very, very quickly. And he is executing a lot of the Biden agenda, as a one-man band. He's rescinded over 10 of the massive guidance letters that had been very employer-oriented. A number of the GC memos and so forth, all of these were issued under the Trump NLRB. And in essence, he's moving forward really with the Biden agenda immediately. In essence, the goal is going to be to empower the NLRB, or basically re-empower it, to provide more worker protections and more extensive remedies for violations. Under the Trump administration, the NLRB had been, if you were an employee side or union side person, you'd say they were pathetic. They didn't do anything to protect employees. In fact, what they did was roll back a lot of employee protections, reinterpret a lot of the different rules, and everything would have favored employers. We're going to see rollbacks of all those policies. I mean, again, as I said earlier, the pendulum swings. We see flips and flops, yes and no. It just back and forth. It'd be really nice if there was some consistency from administration to administration, so that employers and employees alike could adapt. But as I said, there's going to be a focus on strengthening worker organizing, collective bargaining, corporate accountability, there is a goal to eliminate as many right-to-work law state statutes as possible. We still have a lot of right-to-work states in this country, and the goal is going to be to eliminate some of the laws that make it possible for employees who choose not to be members of unions to not be members and not pay union dues and so forth. There's also the PRO Act, which is the Protecting the Right to Organize Act, and that's going to be really a ripping down and rebuilding of every single thing on the wash list that Mr. Obama and Mr. Biden had been working for over the years. And if the PRO Act passes, I really think it's a brand new era for employers. And we're going to be back to dealing with our handbooks. We're going to be back to dealing with really difficult situations before the National Labor Relations Board, even for employers who aren't unionized and aren't dealing with worker organizing. It would just be basic employers, because all employees have Section 7 rights, and we're going to see more private employers being sucked into NLRB proceedings if they have their way. But I think change will come more slowly due to the current makeup of the board. As I said, and I believe in August, there's going to be a change there, but that's going to be a tough one. And if Mr. Biden has difficulty getting some of the pay equity stuff through the legislature, through Congress, excuse me, he's going to have way more difficulty getting some of the National Labor Relations Act revisions through Congress. So this is going to be interesting and fun to watch. Let's move on to the Biden OSHA, the Occupational Safety and Health Administration. This was an agency that I personally felt sorry for. This agency is such an important agency to the American worker. Without OSHA, people would die of accidents, diseases, and all kinds of other problems at work on a much more regular basis than they do now. Remember, Richard Nixon actually created OSHA back in his administration. That's when Republican presidents actually, did things like that. In any event, OSHA from 2017 to 2020 was lower profile, but it was doing a lot of behind the scenes work, getting ready for a change. I mean, they were just busy without being able to be brazen about it. In 2020, they had a focus on COVID. They issued a number of non-mandatory guidances because they were not allowed to get deeply involved. As I indicated earlier, Mr. Scalia didn't want them involved with the COVID issues. Now, OSHA is already diving into the pool. It's a higher profile. We're going to see a renewal of their strength and a reinvigoration of their activity. We're going to see Mr. Biden says he's got the goal to double the number of inspectors. So we'll see more inspections, more enforcement. He's already named Jim Frederick as the acting deputy assistant secretary for OSHA. And I just feel that when we look at OSHA, we're going to see that agency roar back to life. And it's not going to be so much about enforcement with them as it is going to be about training, educating, working with employers to make sure everybody's up to speed. And after they're satisfied that they've done what they have to do on that side of things, that's when they'll start their enforcement. But OSHA is invaluable to the worker safety, and it's been sad to see them basically had their head held underwater for the last couple of years. Now let's talk about more of the Biden OSHA, and this gets back to COVID. I'm going to zip through these slides because I know we're getting a little short on time. But as I indicated, President Biden issued an executive order on January 21st requiring OSHA to issue updated guidance, and they did so. The guidance is called Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. It includes non-mandatory recommendations to assist employers to recognize and abate hazards. It is advisory and informational, but it signals OSHA expectations for the emergency temporary standard that has a target date of March 15th. I do commend you to take a look at the guidance if you are seeking a more structured approach or information all in one place. The guidance itself focuses on the CDC recommendations and combines them with their own guidance, but it does provide recommendations. I'm not going to read them all to you, but these are all explicated in the OSHA guidance on their website, so I would commend it to you to read. The prevention programs, they provide not only key measures for limiting the spread and discussing the roles of employers and employees in responding to it. They're really focused on making sure that employers get up to speed in a consistent fashion with each other. So my sense of this is that OSHA is going to put a lot of effort into doing what it was not really permitted to do until now. And we'll see better guidance. Employers are going to have much better guidance in terms of how to achieve things rather than cobbling it together based on CDC standards and 50 different states standards that have been impacting employers. With respect to the OSHA as well, we're going to see some other anticipated changes. General duties clause is the bane of most employers' existence because that's the catch-all, but we're going to see more general duties clause citations relating to COVID-19 and the violations of the CDC guidelines. Again, once OSHA believes employers have had an opportunity to get all this stuff up and running, they'll start the citation process. It'll be nice to see the resurrection of the permanent infectious disease standard. Interestingly, the Obama administration had put together a massive pandemic project before they left office. They spent years studying, working, and putting together a pandemic resource that was left for the Trump administration, and which basically got thrown in the trash on the first day of that administration. Had that been available to the United States public, perhaps things would have been different. And I'm saying that, again, as my personal opinion, but it's something that already exists. And with some fine tuning based on what we've learned from this pandemic, I suspect we're going to see permanent infectious disease standard issued quite soon. The OSHA anti-retaliation rule, let me suffice it to say that it is okay for an employer to drug test an employee who reports an accident at work, so long as the employer has a reasonable belief that the employee may have been involved either in the accident, maybe under the influence of drugs and so forth. What was happening under the anti-retaliation issue was that employees were afraid to report accidents at work because they didn't want to be drug tested. And a lot of employers were drug testing, reporting employees simply in retaliation for reporting the accident. So we're going to see an enforcement and a reinterpretation of what has happened to that rule. But I think we'll see a new product, and then anti-retaliation will be issued. So employers will not be permitted to retaliate against employees who report workplace accidents, because it's better to report that accident than to not. We'll see OSHA and state OSHA agencies. We're going to see more interaction and oversight there. A lot of states have their own OSHA, so they're not typically following federal OSHA guidelines. And I think there's going to be a move to kind of homogenize as much of that as possible. And we'll see some additional updates having to do with reporting. Some of the proposed legislation that is out there, the Family Act has made it through the House, as has the Paycheck Fairness Act. In any event, the Family Act is focused on providing paid family leave. And so it's basically wage replacement for employees who would take time off work as if it were under the FMLA. So it would be really for an employee's own serious health condition, the birth or adoption of a child, to care for a child's spouse or parent with a serious health condition, and qualifying exigencies arising from military deployment. Under the Raise the Wage Act, of course, we all know that that goal is to raise the wage to $15 per hour by 2025. That's what the goal is there. The Equality Act is the LGBT anti-bias law, and it's really an effort to not only codify Bostock, but to expand that coverage into housing, accommodations, and education. The American Rescue Plan was passed February 27th by the House, is now sitting in the Senate after over an 11.5-hour reading of the bill in order to kill time. We'll see if the Senate passes it. I expect they'll pass it, but I could be wrong. And then I mentioned earlier that there will likely be some move at the federal level to limit or eliminate non-competes and no-poach agreements. You can never eliminate all of it, particularly in the sale of a business, but a lot of mobility, employee mobility, is impacted by non-competes and no-poaches between employers. And I think Mr. Biden's goal is to allow people to move more easily among jobs in order to continue climbing up the wage ladder. By not being allowed to move, you often can't get a better job with more pay, and you're either stuck where you are or you have to do something else for a year or 18 months and so forth. So we're going to see that. I don't know when that's going to pop, but I wouldn't be surprised to see that sometime maybe in year 2. All right. And the rest of my slides really focus on how will the Biden labor agenda impact enforcement activity by federal agencies. I'm just going to slip through these because ultimately I know I'm out of time and Catherine is a strict taskmaster, but we'll see basically everybody turning back to an enforcement posture, more audits, more administrative litigation, more emphasis on pay equity. Oh, the rise in retaliation charges. We're going to see a lot of that, particularly with respect to COVID. And because LGBTQ is now considered sex for sex discrimination purposes, we're going to see a lot more action there. The Me Too movement will continue to play a big role, but it's kind of taken kind of a middle seat, not a back seat in recent months. Again, OSHA will return to pre-Trump status with a larger role in COVID suppression. And we'll see more wage and hour audits, more joint employer reviews, more independent contractor and gig worker reviews, more wage-related audits by state agencies because they're going to be supported by the federal interagency behaviors. And really just strengthening of federal labor policy, more enforcement, more family-friendly legislation, more rulemaking, more things that employers don't like. So really it's back to buckle up, everybody, just buckle up. And I truly hope that you've enjoyed this program. If there are questions, we'll take them. And I believe Catherine has indicated too that if we can't get to your questions, we'll certainly respond to them via email. So thank you all for your cooperation and attention. And I'm going to turn it back over to Catherine.
Thank you so much, Catherine. I very much appreciate it. That was an excellent presentation, full of all kinds of obviously new information for us. And so we do have a few questions. The first one is, this relates to your comments about the OFCCP. And so the question is, can you talk about who falls into the category of a government contractor? And should we be worried if we are handling COVID testing or vaccination sites?
Okay, that's 2 interesting questions. Somebody that is a federal contractor is typically an employer with a federal contract of $50,000 or more dollars. Some of the smaller contracts get you coverage. But if you're an employer with 50 employees and at least $50,000 in federal contracts, you're covered by Executive Order 11246 with respect to having affirmative action plans. And then we've got what you call the Minorities and Females Plan, which is Executive Order 11246. And then you've got Veterans, Protected Veterans Plan under BEVRA. And then you've got the Rehabilitation Act, Individuals with Disabilities Plans. And so individual employers that are contractors or subcontractors with contracts in excess of $50,000 are covered by the law and must have minorities and females plans if they have more than 50 employees. If they have fewer than 50 employees, they're still covered by the law, but they don't have to have affirmative action plans. With respect to having a veterans and an individuals with disabilities plans, the threshold for the dollar level is higher. It's $100,000. But ultimately, federal contractors should be prepared to deal with diversity and inclusion and affirmative action. Now, the other part of that question was, should we be worried if we are doing COVID screening or COVID vaccination, I think is the question. I'm going to say it depends, because early in this process, particularly for COVID testing, the different agencies doing the federal contracting were not careful about whether some of the federal contractor requirements applied. And so I would say that now that they've gotten the hang of it, you're still a federal contractor, but your contract with the agency that you're contracting with, whether it's Health and Human Services and so forth, that contract is your roadmap to your coverage as a government contractor. And typically what I've been seeing is that these particular contracts are now excluding a lot of the Executive Order 11246 obligations to have an affirmative action plan and to engage in some of the affirmative action recruiting and to have the plans for veterans and disabled individuals. So I would say that you're still a government contractor, but it is likely that you are not subject to a lot of the employment requirements that a typical manufacturing or other type of government contractor might be. Like a bank is a government contractor in most instances, and they would be required to have all three forms of affirmative action plan. Manufacturers and so forth, they would have all of that. But for these particular services contracts, you're likely a government contractor, but there are likely going to be a tremendous number of exclusions in your contract that says that you don't have to pay prevailing wages under the Service Contract Act, that you don't have to have affirmative action plans in place and do the kind of recruiting that is typically necessary. So the answer is to that one, check your contract, see how explicit it is. And if you have questions about whether you're covered with respect to various aspects of being an affirmative action contractor, contact your contracting officer at the agency you're working with. That's my answer.
All right. The next one's an interesting question. Is COVID a disability for purposes of the ADA?
That's an interesting question, as you said. And the reason it's a good question is because I bet it is, but the EEOC hasn't been in the position to be able to take a position on this yet. And so for now, we are really looking at COVID as, we do the analysis. So if a person had COVID, but they're now healthy, then no, they didn't have a disability. But there are other people that have lingering effects. Perhaps they've got lung damage or other forms of damage resulting from COVID. So I don't believe that we would say that COVID itself is a disability, but the effects of COVID could certainly constitute disabilities going forward. So I think, as with almost everything under the ADA, employers need to really look at everything on a granular, fact-specific basis. The fact that somebody had COVID likely has no impact under the ADA, but the fact that somebody is now still in recovery 6 months later, or maybe had a minor stroke, or has lung damage and so forth, that will get you to ADA coverage. So that
Yeah, that's what I was thinking. Yeah, I was thinking that too. Maybe the effects of something, of COVID,
definitely.
Mhm.
It's sort of like, and I hate to digress or actually go so far
Mhm.
to tangent, but if you're looking at marijuana, okay,
Mhm.
um,
Right.
an employer doesn't have the obligation to allow people to use marijuana. However, if they have health issues that marijuana assists, then they actually are covered by the ADA, and the marijuana is part of that coverage. So it's kind of interesting. So we talk more about effects than the basic facts in those cases. Do you have anything
True.
else for me?
Yeah. No, I was thinking, boy, we could go down a rabbit hole with that one. Yeah. Okay. So, let me, boy, we were running way out of time. Let me ask one more really quick question. Let's see, how will the independent contractor rule affect the use of gig workers? What about task boards and other marketplaces? Is everyone an employee? So do you have anything that's sort of wraps up around that?
Yeah, that's interesting because this whole gig economy, a lot of it is driven by these task boards that are out there. They're just
Hmm.
platforms where people can put, I need somebody to illustrate this, this children's book, or I need somebody to illustrate this group of greeting cards, or whatever. It's just a single one-shot deal, and they get together on this task board and they make their own relationship, they make their own arrangements, and ultimately the question there becomes, is that person an employee or an independent contractor? And that person who is just hiring somebody to do a small project for them, they're not intending to be an employer or pay employment taxes and so forth. So the Obama administration, when they were dealing with both the independent contractor and even the joint employer regulations back in that era, their position was that everybody's an employee. Okay, so under the independent contractor analysis, the position really was everybody's an employee unless otherwise proved. Okay, so I think that as I indicated earlier, a lot of these laws have not been updated, and a lot of the regulations haven't been updated in decades. And so when we look at the wage and hour laws at like 1938, the law hasn't kept up with the times. And so this gig economy has blown past what anything anybody ever anticipated could happen under the Fair Labor Standards Act and the accompanying regulations. And so I think a large scale analysis is going to have to be done into the gig economy and how it really works, and the people who are involved in it and what their expectations are. Because from what I've seen, a lot of the gig workers don't want to be considered employees. Many of them have full-time jobs and they're just doing this as a little sideline here and there, and they like the variation. The other aspect of this too is unemployment compensation. And are these people considered employees to the extent that they would be entitled to unemployment compensation simply because they got a job on this platform? So who's the alleged employer in that case? Is it the platform where the person who needs the task meets the person who provides the task? I have represented a couple of these platforms, and we've successfully been able to keep them from unemployment compensation liability, but it was always a new frontier on that side of the coin, because these are simply platforms, and there's a contract that people use to use the platform. But other than that, the platform isn't taking any money from the employee. The employer pays a fee to use the platform, but it's the platforms that have been alleged to be the employers in these situations, and I think that's wrong. So that's a long way around of responding. I think a lot of the gig workers truly are independent contractors, and what they're probably going to have to consider is doing an independent contractor analysis that takes into account different factual circumstances. I think some of these one-size-fit-all, 5 points or 6 points to independent contractor status, I think that we can't count on those anymore. So there's going to be, again, that fact-specific analysis. I think we're going to see a classification regulation come out, but they're going to have to really focus on the ability of the person making that judgment to see all aspects of it. So I would predict that while the position is going to be that everybody's an employee, I think that that position will be chewed away at. And whether or not they provide us with multiple ways to analyze this situation is yet to be seen. But they've got to focus on the fact that the law never anticipated this, and how can the Department of Labor regulations best adapt to a changing economy. I'm not sure if I answered the question, but
yeah. So you're saying that getting a bit of an echo there. But so you're saying that if somebody was hired as like a 1099 independent contractor, the issue is coming up when they then perhaps are starting to work way more hours, perhaps, than what a gig worker or an independent contractor normally would traditionally be working. Is that correct?
that's a
Or a
good point.
part-time or a part-time worker, perhaps? Because then when do they get into the territory of like part-time worker? What's the difference between, independent contractor versus, a 1099 versus part-time?
Yeah, I think that's a really important point to make. And that gets to one of the elements of the analysis, and that is whether the person relies either solely, exclusively, or in large part on this one employer for their income. And so when it gets into part-time work on a regular basis, unless the individual actually has their own, whether they're a corporation or whether they're an LLC or something else, or they have their own shingle, basically, and unless they're actually providing their work for others, and it's not exclusive to one employer, and there's the person is paying corporate taxes and doing all those things. I think sometimes you'll have that clear-cut picture of an independent contractor, even if they work 20 hours for an employer in any given work week. Maybe it's because the project is long. But if you've got somebody that starts off as an independent contractor and they're only working for one employer, or maybe even two employers in this regard, and they're doing 20 hours a week for each employer, and that's goes on for an extended period of time, I think you've got yourself a real employee, and I think you've got yourself, they're a part-time worker. And so what happens in those situations, the employer says, I can't 1099 you anymore because I'm afraid that I'm going to get audited and then we're going to have a problem. So I would like to hire you, and you can either be part-time or casual, but I need to pay taxes on you, and we're going to have to change the way we do our fee structure. So there's opportunities there for people to get jobs on the one hand, but there's also negative opportunities for people to end up not being able to do fee projects, long-term projects, without being considered to be employees. So it's an interesting issue. I think there's multiple sides to it.
Okay. Well, I wanted to thank you so much for being here today, Catherine. It's been a really interesting issue, and so I wanted to thank you so much. Did you have maybe one or two words that you wanted to leave with us for wrapping up?
Well, as you can see on the slide that I've kept up, it's buckle up. I really do think that employers shouldn't be afraid of the Biden employment agenda. I do think that they're not going to be as happy with new legislation as perhaps over the last 4 years. But as all employers know, the pendulum does swing. So I think a lot of this gets back to go back to where you were during the Obama administration and just get yourself back in that mindset. That's really what I think. I think that things are going to happen. There's going to be reasons for them. And I know that it's a terrible nuisance for employers to have to learn new rules or to be involved in multiple types of suits and audits. And I'm not saying that it's a good thing, but I think they should just get prepared and do it in a calm and careful fashion. Start with self-auditing your wage and hour practices, self-auditing your employment discrimination, look at your employee handbook. Just really start taking a good look at everything in your employment area and focus on what your weakest links are and beef them up. And then with OSHA, make sure that you are paying attention to a lot of OSHA pronouncements because they're going to come fast and thick.
Okay, great. Well, actually, that's a good seg because I wanted to mention to our attendees to be sure they have their eyes and ears open because our next webinar is going to be held on March 23rd. That's the very next webinar, so you'll get information about it. It's going to be held on March 23rd at 1 p.m. Make sure you sign up for that also. And it's focusing exclusively on OSHA and the new safety guidance for the considerations that came out on January 29th. So, and that's by Jennifer Gimler Brady. She's a partner at Potter Anderson and Caroon in Wilmington, Delaware. So if you could, if you're interested in finding out more about the new OSHA guidance, which you definitely should be, make sure you sign up for that too. So you'll get registration information on that later on today after this webinar ends. Catherine, I wanted to thank you so much again for being here today. Thank you so much.
It's always my pleasure to work with you, Catherine, and First Healthcare Compliance. Thank you.
Yes, thank you. Attendees, thank you also for being here. Please use the contact information which you would find. Don't forget to download a copy of the slides that's either on the side or the upper part of your screen. You can also send us questions and we'll forward them on to Catherine. Please remember your PAYCOM and your PMI CEU certificate will be emailed to you from within 2 days following the broadcast. There's no need to request it. You can register for future webinars or request a demo excuse me, of our compliance solution on our website at firsthcc.com or call us at 888-543-4778. And thank you for joining us.